of the law and flawless argumentation style, Sir has aided the Honorable Supreme Court of India to lay down the law for the whole country on various critical legal issues, owing to which his name has been published several times in the SCC in several reportable judgments. He has completed his post-graduation on scholarship in Criminology and Criminal Justice from Queen's University, Belfast, UK. He has also aced several co-curricular activities, such as moot court competitions, by competing against the top teams of Queen's University. He was also selected to train, learn the leadership skills, and discuss the laws of India vis-à-vis the UK with the Royal Military Sandhurst Group, Sandhurst, Berkshire, Southwest Central London, a close security group of Queen Elizabeth II, the monarch of the United Kingdom. Sir is also a law pedagogue. He has coached many pupils to reach the top national law universities, amongst other top-ranking colleges in India. He conducts webinars and workshops under his brand Law Offices of Advocates Jai Wadhwa to educate and instill the nuances of the law. As a result, the same pupils excel in law and secure top ranks in their respective colleges and universities. With this, we now move to the exciting part and give the stage to Sir to talk about all the doubts that materialize in our heads and to discuss how to deal with all the various issues and questions that come with being a law student. The stage is all yours, Sir.
Thank you so much, Varnika, and the entire team of Lawocals for inviting me. Special thanks to Varnika for that very long and very kind introduction. Believe me, I am trying very hard to make it even longer, but be that as it may, it is what it is as it stands today. Having said that, good evening to everybody. I'm absolutely delighted to be with all of you here on Sunday evening as I apprise you of all the things that you are not taught in the law school. And I'm sure that all these little things are very important when you graduate law school and enter the profession, be it you want to become an advocate or you want to become a corporate lawyer or judge, whatever, for that fact. And in the process, I'll dispel all the doubts that might arise. Now, mind you, the subtopics that I'll be covering today or I'll be talking about are very important for this profession. The reason why I say this is because when you graduate, and I was made aware that many law aspirants are also well today, along with many law students and few barristers from the United Kingdom are also present. They must be watching from YouTube live. Anyways, so the points that I'll be covering today, they are very important because they will help you not only to excel in law school, but also to do well in the profession. And all these are experiences which I have experienced, and I have come to know that these are the little loopholes which are not taught to all the law pupils, and they should know about all these things. And whatever I will say, that is irrespective of the fact that whether you want to enter into litigation or whether you want to become a corporate lawyer or you want to become a judge or whatever you want to go abroad, that is irrespective of that fact. But all these little nuances are very important. First of all, because I'm also aware that many law aspirants are also present today, so let me clear this cloud of doubt that. And I'm often asked this question, so what law college to prefer? Any law college. There is this myth that, so if I am in NLU, NLUs are good and other colleges are not good. That is not correct. That is not correct. You get into any law college because you see, yes, NLUs are no doubt very good. You enter into a national university through an exam. That is very good. That's a competitive exam. And there is a reason. There is a reason why tens and thousands of students appear and very few are able to secure admissions into top national universities. This is because it's a competitive exam. And competitive exam does not require knowledge. And I'll come on to the latter aspects in a very short while. But because there are aspirants also here present, this is a competitive examination, and competitive examination need not require knowledge. I mean, of course, you need to have knowledge of what English and all the law and all the other subjects that are asked. But apart from knowledge that you possess, you also have to have a personality. And when I say the word personality, I don't mean that okay, so you are only reading law every day and all the subjects that are asked in CLAT exams. So you are, or if you want to enter International University Delhi, for that fact, you are only studying to only those subjects, those specified curriculum which has been given by the respective university, and then you will enter that college. No, that is not the correct approach, according to me. Apart from whatever you are studying, personality also matters. And when I use the term personality, that has multifarious dimensions to it. One such dimension is that when you are studying, don't don't take help or don't rely completely upon anybody else who is coaching you, and that for that fact that whatever he or she is teaching, that's supposed to be the final, and I will not apply my own mind to it. Ultimately, when you enter the law college or even when you exit the law college after 5 years, it is your brain, it is your self confidence and your knowledge which you have acquired yourself, which will be very, very important. So, in the process of giving this competitive examination, you should not only get knowledge, but in the process you should also develop your personality. So, if I was to ask you, and this is supposed to be the question which according to me, should be asked by all the professors to all the students who are in the first semester who have just entered the law college, uh, why the law, or what is exactly the law, or what is the essence, or what is the importance of subjects like, if you're doing BLLB, what is the importance of subjects like history, subjects like economics, subjects like pol science, subjects like sociology? Why do you need to study these subjects along with the law? Now you see, in order to be a good lawyer, and this is very important, in order to be a good lawyer, you need to develop power of persuasion. And power of persuasion requires logic. This is what is not taught to you in the law college. You see, you might become an advocate, or you might become a corporate lawyer, might become a judge, or for that fact, you are arguing in a moot court in your college. You need to have power of persuasion, and and in order to have that power of persuasion, you need to get logic. And where will you get that logic from? You will get that logic from knowledge. But be that as it may, this power of persuasion is, or the power of persuasion cannot be taught to you by any law school for that fact. You enter into a National University Hyderabad, or for that fact any college for that fact, law. This power of persuasion you will yourself develop. And how will you develop it? You will develop this power of persuasion and logic that goes with it by knowledge. Now the question arises is, how do I get knowledge? Now you see, knowledge is not only, you don't get knowledge only from books. You get knowledge from wide variety of sources, be it YouTube, be it journals, be it any online law tools like SEC Online, like Madhupad, or whatever for that fact. My first point to you and to everybody is, develop that logic, develop that critical analysis. You don't develop that. The reason why you don't develop that is, and I will come to there are multifarious reasons to it, and I'll come back to all the reasons in a very short while. But you need to develop critical analysis, question anything and everything that you read. Why? Like I started this topic by asking you why the law, or what is the law. You have to ask this question. This question, unfortunately, is not asked, is not, you are not compelled to ask this question to you or to your professors for that fact. But you need to ask this question. So if I have to answer this question as to what is law, you see, according to me, law sets out parameters for relationship. And when I use the term relationship, I mean relationship between the society and the individual, relationship between the society and a community, relationship between community and for that fact e-commerce society, because you order stuff online these days. So your relationship with the e-commerce. So all the aspects, all the aspects of societal interrelationship is what is law. Uh, as I'm able to recall, law also regulates relationship between husband and wife. Law also regulates relationship between children and parents. So this is what is law because it sets out the parameters according to which the society or the community interacts with other counterparts. For example, state for that fact. But having said that, you will ask me, oh, well, this is okay, but how should I move forward? Well, to answer this, you being a and this is supposed to be the second point, you as a law student should gain knowledge of every aspect of the law. In other words, every aspect of human relationship. Don't confine yourself to only one particular set of law. So when I was in law school, I made this a point that I will get hold of knowledge, be it criminal law, be it arbitration, be it civil law, be it company law, because at that point of time, our mind is such that we don't know as to what field we will choose. So until and unless you don't get knowledge of every aspect of the law, you will not be able to decide as to what field you have to choose. And you see, law is not, and I always tell this, law is not only law, it's a mix. It's a mix of economics. It's a mix of literature. It's a mix of history. It's a mix of philosophy. It's a mix of sociology. And that is the reason you are taught all these things in law college. So when you are taught sociology, you don't pay importance to sociology, thinking the fact that how will the sociology help in law? But sociology plays a very vital role when you are practicing in criminal law because you have to understand what is the aspect or how the society is affected when a crime is committed in a society, in a community. There's a sense of shock which is created in a society whenever any crime happens. So you have to understand, you have to look the society from the lens of society also as to what the society feels whenever a crime has taken place. And that is the reason you are taught all these BA subjects along with the law. Because the ideology behind this is so that you are able to interconnect. Because everything is interconnectable. Everything. Be it economics, be it sociology, be it psychology, be it history. I'll give you an example of history in a very short while. But let's talk about economics. Budget has recently come. How many you ask yourself? How many of you have debated on budget? How many of you know what is a fiscal deficit? How many of you know what is a GDP? How many of you know what is a repo rate? So when you are taught economics in college or in school for that fact, you don't pay attention. But these are all very important things when you are studying law. Because you see, when I argue in court, yes, obviously 99% of it has to be the law. But in order, and this is what distinguishes a normal or mediocre lawyer, if I may say so, with a good lawyers. Because when a good senior lawyer is arguing, he is mixing law with literature to prove his point. He is mixing sociology. He's talking about the mindset of the society with law in order to prove his point. So this is where all these BA subjects will help you in order to in the profession. Now you want to become an advocate, you want to become a judge, irrespective of that. Talk about literature. And I just told you it helps you to prove your point. When you're quoting a quote that's given in the literature, that helps you to prove your point in the court of law while arguing. You talk about philosophy. You should study great philosophers like John Locke, like Hobbes, like Karl Marx. So, but all these are foreign authors. You talk about Dr. B.R. Ambedkar, and who's the framer of the Constitution. Now, I'm sure all of you know this. He was a Dalit. Can you imagine that man was made to sit outside the class every single day, because at that point there was a huge flow of casteism, and he belonged to a Dalit class. He was not allowed to drink water from the same well as other Brahmins who used to drink water from. Still, he was determined that he wants to study, and that is where the power of persuasion lies. Because if I am persuading you to do anything, then I have to give you logic. I cannot talk nonsense, and I cannot expect that you'll be persuaded by my arguments for that fact. So all these subjects, be it economics, be it literature, be it history, be it pol science, or be it psychology or sociology, all these things are important while studying the law. So if you are in the first or second year of or third year for that fact of your law college, make sure you. I'm not saying to master these subjects. What I'm saying is you have to have a basic knowledge of all these things. That will definitely help you. That will enhance your answer writing skill for that fact. That will People will listen to you when you are talking, because they know that you will be mixing a lot of things in order to prove your point. And this is where your value will be enhanced, because this is a clear fact. This is an established fact that you cannot persuade anybody without logic, and logic comes only from knowledge. Now, the second point which I want to address you on is and I was referring to this a while back, was critical analysis, the logic. Whenever, and this is I think is supposed to be the biggest mistake which you commit while you are in the law school, that you don't develop this habit of critically analyzing things, or you don't develop this habit of asking logics or asking the question why from your professors, whosoever is teaching you. You see, I'll tell you, in the initial days of my college and my initial period of struggle, my mom always used to tell me that she used to tell me, uh, पढ़ाई का काम होता है दिमाग को जिंदा करना. If you are not critically analyzing whatever you are studying, if you're not applying your mind, that means your brain is dead, and you're doing rote learning. You're doing rote learning, and you will not succeed in the profession of law until and unless you question anything and everything which comes to your mind. Have developed this habit of asking your professors why this is like this, why not this. Develop this habit. Whenever you are reading a statute, whenever you are reading a statute, don't limit yourself only to the cold print of the statute as to what is written in the sections. Don't limit yourself only to the cold print of the statutes. Go behind that statute or go behind that section Because every law has a soul. Every law has a soul. And when I say this, I mean whenever you are studying any law for that fact. So the approach in college should be that first and foremost you have to understand as to what is the jurisprudential essence or the constitutional essence of that law. Because you see, and I'm sure you're aware also, that constitution is supposed to be the grand norm of the society. It is the basic structure of the constitution which will prevail. So any and every law which is made by the legislature has to abide by the basic structure of the constitution. So you have to do interlinking and intralinking with the constitution as to what was the mindset of the legislature while drafting this law. So for that, if I have to take an example, what is the jurisprudential essence of criminal law? Because my specialty lies in criminal. So what is the jurisprudential essence of criminal law? Because you see, jurisprudential essence of criminal law is that the legislature has to draw a line. That the legislature has to draw a line. When I say line, I mean the balance. The legislature has to do balance. And when I use the term balance, I mean balance with vis-a-vis the society as well as the accused. From the aspect of society, it is in the societal interest that the society wants that the accused should be given the maximum punishment possible. Because if that is if that happens, it sets out a deterrent effect to the society that look, if you commit this crime, you will not be spared, you will get the maximum punishment possible. But on the other hand, you have to take care of the fundamental right to life and personal liberty of the accused also. Because, mind you, the term used is accused and not guilty. He is just accused of a particular offense. He will turn guilty when, in the court of law during trial, evidences are given and it is all the charges are proved. All the charges are proved. So a balance has to be drawn. And this was the mindset of the legislature, that we have to draw a balance between the societal interest and the individual interest. This was the jurisprudential essence of criminal law. So whenever you are reading any law, make sure that you first start with the jurisprudential essence of that law and not to start with all the sections directly. Pair Act anybody can read, but what people don't read is jurisprudential essence. Jurisprudential essence will make a very clear picture in your mind that look, this is the jurisprudential essence of this law. So whatever provisions I will be reading, all these provisions will be linked towards the jurisprudential essence of that law. So be it the provision of arrest, be it the provision of producing the accused before the magistrate within 24 hours, or be it the provision of lodging of FIR 154 or 156 or 157, whatever it is for that fact. Link it with the jurisprudential essence. That will help you not only in the law school but also while you're arguing in the court of law. But and also, and this is very important, when I say that you don't have to restrict yourself only to the fine print of the law, I mean that whenever you are reading any section, break the section and try to understand each and every word. Varnika was in my introduction was referring to the workshop that I conduct. I for somebody who has attended any of my workshop for that fact, you must have seen I have this habit of breaking the section and understanding the section threadbare, because this is how you will only learn law. Because you see, and this is what was told to me by my parents also, but I knew for this fact that when I was going to England, I was not going there to get a degree or get a foreign education of law. No, or for that fact, scoring good marks. I went there to broaden my horizons. that when you talk of criminal law, you have to understand from the perspective of an inmate also. So don't study for marks in nutshell. I want to say you will, if you have knowledge, if you have read the law, if you have read books on it, you will score definitely. You have developed this habit of making notes, of memorizing notes, of reading the sections and quoting the sections in the law exam, or reading 10 judgments and quoting them in the law exam, in the law paper, so that you can get good marks. Marks should be the least of your priorities when you are in the law school. Your priority should be to understand various aspects of the law. And what better way to understand when you have a supporting hand of your professors? This is a very big mistake that you are committing in a law school. And then when you are exposed to the litigation world, when if you have to enter litigation, you feel that you don't know anything. Because when you were given an opportunity to understand the law, you did not grasp that opportunity. My point to you here is that when, irrespective of the fact that whatever semester you are in, always try to be ahead by one semester. So, for example, if you are in the sixth semester, not you have to study sixth semester, but you also have to understand that you see, criminal law can be related to law of torts. CPC, which is the Civil Procedure Code, can also be linked to CRPC. Now, this interlinking is not taught. Without interlinking, you cannot understand the law. That is for sure. I have tried this and I have come to a conclusion myself that without interlinking or interlinking for that fact, you cannot understand the law. Because law, you cannot see law in just one isolation. You cannot see CRPC or CPC in one isolation. You have to see it from the lens of constitution. You have to see it from the lens of other laws also. So when you are understanding bail in CRPC, try to link it, try to link bail with bailment in in contract law. Do this. It will definitely help you, I'm telling you. And and this is what I feel that you should be aware of and you are not. You are not taught interlinking or interlinking. But irrespective of that fact, you should know this. You should know how to connect, because this power of connectivity will ultimately help you when you will argue before the judge. And judge will also appreciate that, look, he's able to connect different laws at the same time. He's able to tell us as to what was the intent of the legislature behind drafting this law. Right now, this issue of hijab is going on. Did you ever try to think as to why as to why what was the constitutional essence behind hijab? You are hitting on somebody's, okay, so if in a very simple terms, if I have to say, the state is directing a Muslim woman what to wear, what not to wear. Does Article 12 provide for this? Because Article 12 of the Constitution of India defines state. So does Article 12 gives such enormous powers to the state to define as to what will a particular community wear or not wear? How do you link it? How do you link it with Article 21 of the Constitution? So all these interlinkage will help you come to a conclusion, and then only you will be able to debate in your society, in your law college. So this is very important. And when I was talking about threadbare understanding the section, so for example, if I have to take an example, when you read section 200, this is one random thought that's come to my mind. When you read section 200 of CRPC, now section 200 CRPC defines complaint to the magistrate. It defines complaint to the magistrate. So when you will read that section, you will come across the word shall examine on oath. Now you forget the section and understand the word shall examine on oath. Who are there? Whom are the legislature wanting to examine? Or that to an oath? Because you see, examination is also done when the complainant files a complaint before the magistrate. So are they referring to that examination? Because that examination is not on oath. This examination they're talking about on oath, and not only of the complainant but also of the witnesses. So what examination are you talking about? Then you will come across a word present if any. You have to understand the word if any. Any and you see each word written in a section has its own particular essence. Be it the word may, be it the word shall, be it the word to decide or whatever. It is your duty to understand that each word. And this is where I always insist that you have to take help from your professors. Because outrightly, they have to teach you. But if they are not, because of paucity of time for or for that for any XYZ reason, it is your duty to go to the library, pick up any commentary on that particular subject, read that section. Because when you will read that commentary, each and every word given in the section will be very detailedly explained in that commentary for that law. People often ask me, why have you, how, not why, how have you reached the top so quickly? And the reason is this. The reason is simply this, that I know very well. I don't, you see, the reason is that I, it is very clear to me that it is only me that has to do it, and nobody else will give it to me on the platter. I don't rely upon anybody else to teach me law. You don't rely upon your teachers to teach you law, because your teachers will not come to your aid when you're arguing in the court of law. It is your own mind which will help you. So these 5 years that you have got, make sure that you take or that you suck maximum out of it. I always say that law colleges are not meant to be fun colleges that you cannot have. You cannot go out on to watch a movie or whatever you want to go out. You cannot enjoy, and that is correct. That is correct, because you see, law is very important because law is involved everywhere. Is everywhere. You talk about the profession of doctor. There are cases of medical negligence. Law is involved. So law is involved is involved not involved. Law is involved everywhere. So it is your duty, and that is why I say I told you in the very beginning. It is your law defines the parameters of human relationship. Now there has to be a relationship between a doctor and a patient, between husband and wife, between children and the parent. The law will regulate each and everything. So, so you have to keep your mind open and you have to broaden your horizons when you are in the law school. Don't depend on anybody. Don't study for marks. You will get it. Today, who is asking me that whether from what law college have I done my LLB or BLLB or LLM? Nobody will ask. Nobody asks. What people are concerned is how fast can I get them the relief? And they only come to me because they know that the knowledge of law, whatever little I have, the knowledge of law is there with this advocate. We have to go to him when it comes to criminal or for that fact, any other law. And one aspect of this, I'm sure that is not taught to you, is punctuality. You have to be punctual. And when I say punctuality, I mean punctuality not in the sense that when it's you have to attend a class at 9 o'clock, so you will go there to the college at 9 and sit. No, you have to set out a routine for yourself. But before that, you have to maintain a diary. You have to maintain a diary where you have to take out the list of to do every day, because until unless you don't have the agenda, you will not be able to maximize your time. You will not be able to maximize your time. So, so it is, just to sort of conclude this point, you have to go behind the law, behind the wordings of the section, in order to link it with the jurisprudential or the constitutional essence of the of that very law. That is very, very important. And develop this habit of asking questions. The big problem which I see today with the law students is that they don't ask questions to their professors. Whatever they are teaching, they are keeping silent, especially when we are in the time of COVID, when where we are studying online. You think that okay, we are here only for the attendance and stuff like that. No, that 1 hour or 2 hours of your class time, whatever topic that is being taught to you, that is very, very important. Whatever law that is being taught to you, start asking questions. And wherever you think that this the wrong thing is being done, raise a voice. And I very often say this: if you cannot raise a voice to defend yourself, how will you raise a voice to defend your client? You don't raise voice. You say, "Ki, theek hai, whatever she is teaching or he or she is teaching is okay. We'll get marks eventually, we'll cheat, we'll get marks eventually, and we'll pass it." That is not how it is done. Because even though you might survive 5 years, but you will not be able to survive the rest of your years in the profession. Because this profession is very demanding, but more than that, in this profession is very challenging. It's very challenging. You have to be on the toe every day, because every day Supreme Court judgments are coming. And I'll talk about in a while as to how to read judgments also. But every day a law is being evolved. Every day certain part of it is getting struck down or it is upholded by any judgment of the court. And one thing I want to point out here is that yes, of course, we are living in the 21st century, so the technology is there, but develop this habit of reading books, reading journals. Now, with the advent of iPads and laptops and everything, we have lost touch of reading hard books. Don't leave that. Don't leave this habit of reading hard books every day. Make it a point every day, and nobody will tell you this in law college. Every day you have to spend about 2 hours or 3 hours in the library, just going through the books on that particular law. You should be knowing what are the good authors on that particular subject, be it Hindu law, be it CRPC, or be it CPC, whatever for that fact. You have to spend 2 3 hours every day in the library or to yourself, and that is why I always say that lawyers, they don't have social life. I don't have a social life, and when I say I don't have a social life, I mean that I don't go out to party. I cannot afford to. Why? Because tomorrow, if a client comes and if he poses his question or his case to me, and if I'm not able to answer, he will not come to me. Will not come to me, and client will always give me money. So you don't want to give your hard-earned money to somebody who does not know who does not know law on that topic. I'll give you a very good example. So I'm doing this. I'm doing RERA cases a lot. Now the RERA, the Real Estate Regulatory Authority, the RERA came into force in the year 2016. Now you see, every law stands in balance when it is made. The burden of proof lies upon that party who claims a particular point, who claims a particular fact. But RERA starts with this presumption that the buyer is correct. So the tilt of the RERA is towards the buyer. So the burden of proof is less upon me and more upon the builder. You have to understand this. So you have to know that that a tilt of the court is towards me. So you don't have to. I mean, if I can say this in a very in a very simple way, you don't have to tell the court a lot of things. You have drafted your complaint, argue before the court, and that is okay. It is the builder who has to satisfy the court of my wrongdoing, of my wrongdoings. So understand the essence of law when it is made. So in other words, understand the essence of the act when it is drafted. So when you're reading a particular act, for that fact RERA or that for that fact CPC or any other law for that fact, understand why it was made in the first place. And then only you will be able to connect various sections with each other. And without interlinking and intralinking, you cannot understand even one single word of the law. That is for sure. I was talking about linking, studying law and linking it with sociology and linking it with economics, history, or whatever. We have lost this habit of reading newspapers. That is wrong. If you don't know, and I am often asked this question, sir, how do I prepare current affairs? Current affairs is not to be prepared. Current affairs is not to be prepared. You should know what is happening in your country. I'll give you a very good example. I'll give you an example of relating law with history. So there were three countries who were born at the same time. In 1947, India was born. In 1947, Pakistan was also born. And in 1949, China was born. Today, China is in the race to become the superpower. Or if I say China is superpower, I might not be wrong. Why? Because of the decisions that China took. Today, there's a possibility of a world war, a war between Russia and Ukraine. Have to understand why it is happening, and then only you will be able to debate. You people have lost this habit of debating. And when I say debate, I don't mean fight. To have a healthy arguments, and you should not wait for any competition to have debates. Just like that, you should talk it out with your friends in college. That look, this is the current issue going on. What do you have to say on this issue? Exchange ideas, and then only you will grow. Because because I don't know whether you've been to court, and obviously in the COVID pandemic times, courts were doing online. So, but when you go to court, when you argue, you never know what point is raised, and your position becomes very awkward when you claim to be a good lawyer and you don't or you cannot comment on a particular thing. So, a holistic view on any subject is must is must. Having said that, that brings me to my next point: the mixing of the theory along with practice. So you are reading the theory, pardon me. So you are reading the theory. And when I say theory, I mean you are reading the books on that law and everything. But when it comes to practical application of that law, you don't know. And unfortunately, when you go to do internships, you also still don't know. Because internship is ultimately for the period of 1 month. So you don't take it seriously. Let me be very honest in telling you, just studying the law is not sufficient. You need to know that look, if 438 CRPC defines anticipatory bail and it sets out the procedure, of how anticipatory bail will be given, how the opposite party, which is the public prosecutor, will be given an option to, will be given a chance to argue. You need to know how 438 is actually done in the court of law. And how will you get to know this? You will get to know this only through internships. Now, I'm sure many of the law students are in the midst of internships. Please understand this. Your college tells you to do internship. You, without even doing research, all the lawyers, all the list that you have of all the lawyers, you keep sending on there all your CVs to all those lawyers, hoping that he or she will say, okay, I accept you, come as an intern. This is absolutely incorrect way of doing an internship. Let me be very frank with this. Because there is a reason. There's a reason as to why you're not successful in doing internship, or you don't learn much in internships, is because you are choosing wrong lawyers to do internships with. You are not doing research. You are not doing research while selecting a lawyer for internships. Every semester, if I'm not wrong, every semester you're supposed to do internships. Did you ever think that, okay, that in this semester I'm planning to do internship with a criminal lawyer. This semester I now I've got to know about criminal law, little bit of practical aspect. So this semester I'm planning to do internship with a civil lawyer. Or this semester I'm planning to do internship with a lawyer who practices ADR, alternate dispute resolution, which is arbitration, etc. When you plan that you have to do internship in criminal law, then search then search what are who are the lawyers who are practicing in criminal law. So for example, you have searched and you have finalized about 5 odd lawyers. Then send your CVs to that do only those 5 lawyers. You don't send your CVs to 100 lawyers anticipating that any one will reply and I will do internship, because this mindset is developed because you have to submit a certificate. And to top it all off, your college never asks as to what have you learned in the internship. Hence, the end result is you don't know the practical aspect of the law. Because theory to you can understand. That is written in the book. You will read the book, theory you will understand. But you will not understand how the practical aspect works. So stop sending your CVs to 100 lawyers. Channelize this, do research. You have the net, do research. That if I'm in the 4th semester, I have to do internship. I am planning to start my internship with a civil lawyer. Now, if you're living in New Delhi, go on the internet, see what all lawyers are practicing in civil law. Everything today is available on Google. Everything. Search 10 different types of lawyers who are practicing in civil law. Go on their website. Study as to what areas are they practicing. Go and see the office. Go and see the amount of work that they have. Because at the end of it, it is your life which is at stake. So, however you mold it, it is your decision. Stop sending your CVs to 100 lawyers. That's a very wrong way to do internship. And I'll tell you why I'm saying this. In England, you don't call internship, you call apprenticeship. And you have to do apprenticeship with a law firm. So if I have to do an apprenticeship with a law firm who is practicing in energy laws, there will be 5 or 10 odd law firms who will be practicing in energy laws. I will go on their website. I will see what the area of energy law are they practicing in. What are the recent cases that they have done in energy law? What is the number of strength that they have in their office? Because, and strength is very important, because if you have 20 people along with you doing internship, you will not learn even one thing. Approach a lawyer who takes only 2, 3 interns. This is a very wrong practice which has developed over the period of time, that one lawyer is taking about 20 interns. And the interns are also not objecting. Why? Because of two reasons. One, that he's getting internship certificate. And number two, he's interning with so and so lawyer of Supreme Court of India or so and so lawyer of Delhi High Court. That is a completely wrong approach. You will not. You are not supposed to show off that, look, I am interning with the so and so, with the additional Solicitor General of India. Question is, what? How much have you learned? I started my career, but before that, I did internship in Tisazari. District courts are supposed to be the court where you start your life with, be it the legal. I'm talking about legal profession of advocacy. You have to spend considerable amount of time in district courts, be it Karkaduma, be it Saket, be it Tisazari, be it whatever district court, Rohini. You have to do your internships there. You have to start your practice from there. Don't be under this fairyland that, look, I have done internship with Additional Solicitor General of India. That will look good only on paper, but here it will be zero. Because please understand this. If one advocate is taking 20 interns, can you expect that lawyer will teach you something? So approach that. Do it. The problem with you people is that you don't do research while applying for interns. I 6 months back, I received about 70 odd applications, series for internships. 70. I am very clear with this that I will only take 2 interns. Very clear. Because my aim is to teach that, look, in theory you have understood this, that look, similarly, that law is this way applicable in practice, this way applicable in the court. You don't do drafting in internships. You, at the end of the day, if, and correct me if I'm wrong, you only pick up files. You go, you see what dates and what court, what in what item number is currently going on what court, and that is what you call internship. You do little research. That's okay. That is not internships. That is doing clerical work. You're not supposed to be clerks. You're supposed to be advocates. And that is why I say, raise your voice. You are an advocate or you are about to become an advocate. Raise your voice against, if you think something is not going correctly. Everything is defined. Everything. Clerk has to do his work. Advocates and associates have to do their work. You are in the midst of becoming an advocate, not clerks. So do what is the role of an advocate. Research, I will come to it. It's a very important thing. Research is basically an art that is very, very important. And how to do it, I will tell you. But please understand, don't do internships just for the heck of getting certificates. And one next big mistake that you do is that, so suppose I have done internship with X lawyer. 1 month has got over, I've got the certificate. Now come back home and introspect. And this is what your local does not tell you. Introspect. What did you learn in the 1 year? In the 1 month. What did you learn? Did you maximize your time? Because please understand this, you are not only investing your time, but you are also investing money into it by transportation or whatever for that fact. So when you are doing internships and you've got your internship certificate, come home, introspect and write, maintain a diary, and that is the reason I told you to maintain a diary. To write that, look, this is what I learned, this is the law, this was the law, this is how it is practiced. This is the stage of trial. We did our chief examination in chief. Now there was a stage where stage of section 313, and then subsequently we started the defense evidence stage. So this way you have learned. This way you have learned that look, in theory it was this, but in practice it is different. Maintain a diary, but more importantly, introspect and write everything, whatever you have learned. College will not tell you. So understand this. College will not spoon feed you because by the time you have crossed 12th, you are 18. That is, you are adult. You have to take your own decisions. So when you're approaching a lawyer for internship, don't send your CVs to 100 lawyers. Shortlist and then send. All the good lawyers are on Google. All good lawyers practicing different aspects of law are on Google. If you search them, you will find everything about them. Everything. Hence, your task of choosing a lawyer becomes very easy. So don't do internships just for the heck of getting a certificate. That look, this is the procedural requirement of my college. Otherwise, marks will be deducted. Hence, I have to give the certificate. Here, ma'am, I've done the internship. So if you're doing that, that means you're only doing internship just for the namesake. You've not learned anything. And if you don't learn anything in the internship period, you will not learn anything in the real world, in the practice. Because judges these days, I'm sure, and I'm very convinced of the fact that though many of them are very quite helpful with the young lot of advocates, but many will say that Mr. Counsel, you're supposed to be aware of these facts. And when judges say this, mostly clients are sitting at the back. No client wants to hire an advocate who are committing mistakes in the court of law. So it is your duty to maximize your internship period. So never do internship just for the certificate's sake. So shortlist and then apply and then do internship and when you are doing internship, I'm sure there are different associates also present who are advocates, but younger than your sir, but elder than you. Talk to them. Like, look, I am doing this. According to you, what should be the right path after doing LLB? In other words, network. In other words, make contacts with everybody for that fact. Because you never know who can give you what advice and what advice can help you in your career. When you are in the internship, meet different people. Not only don't limit yourself only to the lawyers of your firm. When you go to the every day, go to the court every day, even if you don't have internship, irrespective. Don't have internship. In my career of 5 years, I only did 2 internships, but maximum amount of time I was found in the court, sitting in different courts. Because when I used to sit in the court, I used to analyze all the lawyers who used to come and argue. That look, and I used to analyze. Okay, so this lawyer probably missed this point. Okay, this lawyer is good in arguing. Okay, so this lawyer is making more fruitful points. Okay, so this lawyer is concising the long fact into short and then explaining the court. Okay, so this approach the court appreciates. Okay, so this practice the court does not appreciate. All these things nobody will teach you. You have to be good observer. You have to be a good observer in order to understand all these things. Go talk to your seniors. But I've seen many interns very hesitant in talking to their seniors. You are not supposed to be hesitant because ultimately after 2 years or after 3 years you will yourself become an advocate. So don't be hesitant in asking your seniors if you're stuck somewhere, be it professionally or be it in your personal life. And when I say personal, I don't mean your household things. I mean what you have to do in your career. Often I'm asked this question that, sir, whether I should choose criminal law or civil law or corporate law, whatever. Now, this decision is completely yours. And that is why I told you at the very outset that as a law student, you have to have knowledge of all the different fields of law. And then when you have tasted slowly, and when you have tasted all the dishes, then sit back, introspect, and then understand, okay, so when I eat this dish, it is very tasty. In other words, when I sit to study this law, it is very interesting for me, and I don't feel that time is running by. I'm very engrossed because whatever law will you choose, because now we are living in the era of super specialization. So we have to understand that, look, this is the field I have chosen. I have to live with this field for my entire career. Now, criminal law is what I have chosen as my specialty. I have to deal with criminal cases throughout my career as an advocate. Having said that, let's little bit talk about research. How to do research. You see, research is an art. There is no set rule. There is no set rule that this is the way you have to do research. Then, in order to do so, the first and the foremost thing when you sit down to do research is that you have to be thorough with your facts of the case. You have to be thorough with the facts of the case. That means you have to know the law points involved. And that also means you have to develop the habit of reading. And that is why I told you to start reading journals and don't limit yourself only to the iPads and the computers and Manupatras and SEC. Master the art of reading and memorizing the facts. So when you master that, you will come to a conclusion that, okay, so these are the facts of my case. This is the law point involved. Now, whatever is the law point, now your duty is to put that law point in the search bar in SEC online, and then various judgments will come. And here only I'm mixing one more point as to how to read judgments. Please understand this very carefully. There, at the beginning, at the beginning, you have to read all the judgments, first page till last page, because, and this is very important, because when you read a judgment, the judge has mentioned the facts of the case. The judge has mentioned what was argued by the opposite counsel. The judge has mentioned what was argued by the counsel who has filed the case. What is the ratio decidendi, what is the law point, and how has the court given its judgment. That way, that way, it becomes very easy for you to, in normal day life, to converse. There is no shortcut to reading judgments. You will not meet any lawyer who will say that, look, this is a shortcut of reading judgments. No advocate can tell you this. Believe you me, because because it does not exist. Over the period of time, when you will read judgments, you will become so fast that you will know. Okay, so this is the fact. I know. So what happens with me today? Because I've got wide variety of experience, so I know. Okay, so these will be the facts. I'm not interested in the facts. What I'm interested in is in the ratio decidendi and how has the court appreciated the fact. So today, at my stage, I can do this. But when I started, I used to read all the judgments from page number 1 till page number 10 or page number 100 for that fact. Develop this habit of reading judgments cover to cover. And with this, that there is no shortcut to reading judgments. There cannot be. So any lawyer or any advocate who is telling you that there is a shortcut, it is absolutely incorrect. And I will strongly disagree. Because because it does not exist. You meet any good lawyer for that fact. Right now, because you are in the college, you are in the formative stage, of your career. You are still in colleges. You have ample amount of time with you. Instead of doing whatever you do on your iPad, download SEC online, or download, go on Google, type judgment related to dowry death or judgment related to abetment to suicide. The judgments will come. Read those judgments, or you take a subscription of Live Law. You will get uninterrupted access to all judgments of the court. Read those judgments, because when you will read those judgments, then you will get a very good clarity. And very important thing. So what I have done is, every day, there are a lot of judgments coming on criminal law. So I need not, because when I'm driving or when I'm traveling, I don't have an opportunity to open up a book and read a judgment. So what I do is, so when my driver is driving and I'm sitting at the back. So what I do is, I open SEC or whatever judgment that has come to me. Okay, so if that judgment is of my concern, I will note down the citation of that judgment in my mobile in the notes. So I will, in other words, and this is very important, in other words, maintain a register. Now that is optional. Whether you want to maintain it in the handwriting form, or whether you want to maintain it online, that is your call completely. I prefer to do it online now. Earlier, I used to do it offline, as in writing. I used to write judgments on each and every topic of law. So, for example, I bifurcated my register into two parts. One register, one part comprised of CRPC, the same register, second part comprised of CPC. In CPC also, res judicata, judgments, res sub judice, judgments, order so and so, judgments. In CRPC, 438, judgments. Like the topic wise, bifurcate the complete law into topic, and then write the landmark judgment. Only the citation, need not write the name, only the citation, and in one line, short point. So that tomorrow, when you're arguing in the court, and suddenly a question comes as to what is the law on this point, immediately your mind will click. Immediately you will open up your mobile. Immediately you will tell the judge the citation of that case. That way, it impresses the judge. That is very good way of doing research. Every day you have to read judgments, because reading judgments will not only help you in the law, but it will also help you in your English grammar and English language. So reading judgments become very important, and you have to read cover to cover until you reach a stage where you know now that, okay, facts I'm not concerned with. What is the ratio decidendi, and then subsequently, how has the court appreciated the fact. So understand this, that reading judgments are very integral part of arguing in the court of law. Somebody was asking me the other day that, what about case laws? That is the judgment. Do we have to memorize all of it? You need not memorize judgments. Please get this thing very straight. You need not memorize judgments. Every topic has one or two or three landmark judgments. So, for example, in arrest, you have Ramesh Kumar, you have DK Basu. So in your register or in your notes in your mobile, you type arrest 41 to 60A CRPC, then write to Ramesh Kumar, DK Basu. That's it. On every topic, you have to know two or three judgments. That's it. And these are the judgments which you can write in your law college exam also, because nobody is interested in reading judgments which are not landmark, especially when you talk about your answer writing skills in your college exam. So every topic has two or three landmark. And okay, so what I did, and this was something which I developed myself. So how to memorize? If somebody will ask me, I will say that, okay, so do this. A for arrest, A for Arnesh Kumar, D for DK Basu. So AAD. So I should do this. Okay, so when you arrest, when you're talking about arrest, AAD. Arnesh, arrest, Arnesh, DK Basu. This can be one way of memorizing the landmarking judgments. So you can develop your own ways to memorize, but you need not memorize the judgments. You can write it somewhere, and then you can so that that is of immediate access to you and cite wherever it is important. This way, you will not only read or okay, so this way you will not only compile the judgments, but you will always have that handy list with you where that list will be helpful in the court of law as well as in your answer writing skills in your college. But most importantly, the point that I want to convey to you is develop the habit of reading. We today in the internet world we have stopped reading. We spend more time on Instagram and Facebook than on reading. And when I say reading, I not only mean that you read law related stuff every time. You have to read non-law related stuff also. Like I am these days I am reading autobiography of Dr. B.R. Ambedkar. Before that, I was reading biography of Justice Ranjan Gogoi. So you have to develop you see if you know and understand this point very important. If you know that somebody has gone through the same path as you are going, and if somebody is telling you to be aware of so and so things, and if you are aware, that will help you to rise much faster. So if I am able to say this in, so these days I'm reading autobiography of Dr. B.R. Ambedkar. I came across this very good quote that he has said. That quote is in Hindi and it says, कि ज्ञान विद्या शेरनी का दूध है. ज्ञान और विद्या whatever you want to call it, शेरनी का दूध है. जो पी लेता है वो दहाड़ने लगता है. Knowledge is something which you cannot substitute. Nothing can substitute. Today, with grace of God, I have reached a place where wherever I go, wherever I am given that privilege. Why? Not because I'm a practicing lawyer in Supreme Court, not because I've just returned back from England, not because of any other thing, but because of the knowledge that I possess. Nobody can substitute that. Nobody. I have met bureaucrats, I have met judges, I have met senior lawyers, I have had this great privilege of briefing the principal and all the big lawyers. Everybody has appreciated everybody, and the reason is only simple. And the reason is your knowledge will matter. Your clothes, your pen, your family background, your the car that you come in does not make a difference at all. The amount of knowledge that you possess, that is what is important, and it will only come when you have the power of persuasion with you. I'll give you a very good example of power of persuasion. When I was in college, I'm sorry I'm exceeding my time, but just pardon me for that. uh, so when I was in college, I somehow forgot to pay my fees on time. And when I was in college, I was fairly not financially not well, so I forgot to pay the fees on time. So a late fine of X, I don't know how much amount that was imposed on me. So with great difficulty, I used to manage my fees. But so what I did was I went to the accounts department and I explained my difficulty, and then ultimately he said that no, you'll have to pay the late fine. So I came out of the accounts office and I was standing. So accounts office, I came out. There was a huge uh, garden or a land, whatever, and then park, and then my main building used to start. So I came out of the office and I was standing and I was thinking how to get that late fine removed, waived off. I immediately went to the principal or the director, whatever you to call it. I explained my situation, and I also explained why this situation was out of my control, along with some, two, three other things. I conversated with her for about 10 minutes, and in 10 minutes, I was able to persuade her, ma'am, that she should waive off the fine, late fine. And you know what? She laughed, and I was, in college, so I had this cross bag, and I was wearing jeans and a t-shirt, and I was able to persuade her, and she was laughing. And so I said, "Ma'am, why are you laughing?" So she said that the way that you have persuaded me, it appears to me that you will become a very good lawyer. I also had a sort of a grin on my face, and then finally, she was able to. She did waive off my late fine. So she called up the accounts department. Finally, the late fine was waived off. What I'm trying to convey to you is that be it the director of your college, be it your principal of your school, be it the judge, or be it the judge in the moot court, your ability to persuade is what will win you the case, and nothing else. Nothing else. You have to, when you're doing internship, you have to master the facts. That is very important. And the only way you will master your facts is when you will read them not once, not twice, but thrice or four times. Initially, to begin with, at least. And subsequently, once you're in the habit of reading facts and reading judgments every day, then you will know that okay, this is where I have to stop. This is where I have to switch to the ratio decidendi, or this is where I have to switch to the findings of the court. So that is very very important. Uh, just to sort of conclude this is this field, and if I this is what my experience says, this field is every day evolving, every day. So in order to be on the top of it, you have to read every day. You have to, because you see, you as a law student or as a lawyer for that fact, there'll be very few evenings to yourself or to your parents. That still today there is a time when I am not able to give time to my family because I'm involved somewhere else. So my point is that you have to develop this habit of not having a social life, of not spending time with your friends, rather spending time with books or somewhere in the evening conversing with your colleagues and discussing a case. Please develop this. Until unless you don't, you will not be successful. That is for sure. And just sort of to conclude whatever I had to say, utility is important. Utility. Because today, if you don't have power, people will misuse you. This is for sure. I'll share a very good example, and I'm known for sharing personal examples, but I'll do this. Uh, Thursday, Thursday, and this is a live example that I'm sharing with you. Thursday, I took my car for servicing. So there was this part which got faulty, so I had to get that part changed. So finally, Thursday was the day when I took out time from my schedule and I went to the service station to get that part changed. Believe you me, that part was not available. But somehow, some other man with the same car had the same problem with that part, and he also was wanting to get the part changed. But fortunately, he was not present, his car was. So when I went and met the GM of that service station, so I introduced myself, and subsequently I was, the way I'm treated is little differently. So he called up his employee and instructed him to get that part of that car installed in my car first. Preference, but most importantly, utility. That person knows what is my utility. And that is not because we conversated for about good 20 odd minutes. He asked me a lot of questions about different laws and etc. Utility. Develop this. Because until and unless you don't develop your utility, people will misuse you. And if you don't have power, people will still misuse you. Power gives you confidence. Don't I Today I see that a lot of motivational videos are available on YouTube, and I fail to understand why people watch motivational videos. I don't share it with everybody, but I somehow fail to understand why. Is there a need to watch a motivational video? The reason why you watch a motivational video is because you don't have power. Because you don't have power, hence you don't have confidence. And where will the power come from? Knowledge. So all these three things are interconnected. Knowledge will give you power. Power will ultimately give you confidence. And once you have confidence, you can achieve anything. But yes, having said that, develop the habit of sitting long hours, develop the habit of sweating, develop the habit of studying the whole night. These are part and parcel or synonyms of advocacy. Only if you want to be a lawyer or an advocate to reckon with. Otherwise, there are tens and thousands and lakhs of lawyers every day. You go to court, you will find lawyers, but only few lawyers are ones who can charge fees, and they say their fees and clients give them. This is the only mantra if I can give it to you. Otherwise, you will hear 10 different lawyers. 10 different lawyers will give you 10 different views, and ultimately, you will be confused. Apply your mind, you people. And this is what I've seen. We don't apply our minds. We don't ask questions. We don't raise our voices. We are saying, okay, whatever is happening, let it happen. No, even during COVID times, the parents have paid the fees to the law colleges. Professors are supposed to teach you. Still, if you are not satisfied, raise your voice. Because if you are not able to raise your voice to protect yourself, how can I imagine that you will be able to raise your voice to protect your client? I feel very bad that look, this is the problem. College is not able to help because a student has raised but nothing is happening. That is a fault somewhere on your part, not on the part of the college, because college is taking fees. Even during COVID times, schools have taken fees. So it is upon you or the student in school to get the maximum out of the professors. And this is one thing which I make sure that I don't know how many of you have attended my workshops or webinars, but this is one point I make sure that I do. I don't care about time. Today also, I think I've crossed my limit. I don't see time because I know whatever I have to convey, I have to convey. Time will come and go. Students who want to listen will be present today. But you people have come to know what it takes to succeed. And look, this is what I've given you. This is what it takes. I very often, those students who attend my workshop, you ask them, they will tell you that workshop is of 3 hours or 4 hours. Sir takes it on for 5 hours. Why? because I'm not commenting on anybody else, but I have this capacity and audacity to teach one topic for 1.5 hours. And that same topic is taught to you in your law college for 5 minutes. Point is, where do I get the content from? The places where I get the content from is number one, books, number two, commentaries, and number three, my practical experience. You at a younger stage, obviously, you will not have practical experience, but you can always share your internship experience. New budget came, I found very few students, very few talking about budgets. And that is the reason. You see, elections, I'm sorry, but in UP, elections are going on right now. In UP, elections are going on. Mostly in UP, vote is given on caste. Why? Why? Because people are not educated. People don't know what is economics. People don't know what is polity. So when you don't have knowledge, obviously on what basis will you give vote? Caste. A person like me, while going to while going to vote, will introspect and will see what government has done, what work for me, and I will vote. At least me, I will vote only for that government who has worked. Now, what government does, what work, that we both know. But at least on ground, whatever I have seen, I will vote on that. Were you watching news today in the morning? All the news reporters were asking कि आपने वोट दिया, किस बेसिस पे वोट दिया? हाँ जी, दे दिया हमने वोट, अब किस बात पे दिया वो मत पूछो. And I was shocked to hear this response from people going to cast vote. Very few I found that were saying that we gave vote because of this high rate of unemployment or because of farmer issue, etc., etc. Why? Because you're not educated. Current affairs is not something to be read for an exam. You need to know because it is happening every day. And you need to be aware. This is one thing. This is one thing which you are taught in England. In UK, I spent about 2 years, about 2 years in UK. Not a single day went by where my professors didn't ask me what is happening in Northern Ireland or what is happening in England, or Jay, please critically analyze this and then get back to me. This is the huge difference in education system in India and England, UK. Whatever they will give you, any assignment that they will give you, they will force you to critically analyze it. And when I say critically analyze it, they will demand that you come out with something different of what it is already published. That is why, that is why I saw many Indian students facing an issue of plagiarism. Because we are not taught critical analysis. We are not taught logic. Their entire country functions on logic and critical analysis. Anyways, so please do. Anyways, I'm so sorry I've crossed my time. And I'm so sorry. Please, that was all I had to sort of tell you. Anyways, I'm welcome to the questions.
That was very informative, and I think everyone who heard this session of yours has left with a very clear idea of what to expect from law and how to approach it in a more dynamic manner so that we
Yes.
don't just limit ourselves to what is taught in law school per se. Starting with the Q&A round, we have handpicked some questions from all the questions asked by the participants in the Google form, as well as some questions that were raised in the chat below. So I think Abhishek, why don't you lead with some questions?
Okay, I'm audible.
Yeah, yes, you are audible.
So, sir, thank you first of all. And then, as a law student, when we enter under an advocate, we are scared and we aren't familiar with the workspace environment or
Hmm.
how to research or even brief a case. Can you tell us how to go about it?
You see, when you are interning with a lawyer, and you see, again, I'm saying lawyer, there's a difference between a lawyer and an advocate. Lawyer is supposed to be that person who only possesses a law degree, but advocate is a person who is enrolled as an advocate with a bar council, and then he becomes an advocate. So there's a difference between a lawyer and an advocate. Be that as it may, whenever you join a law chamber for internships, the first and the foremost duty of that senior should be to tell you not to work, just to see what is happening in the chamber, not to work. Because you see, I have kept interns, I always tell them, because I start with the presumption that you don't know anything. Always I start with this presumption that you don't know anything. You have approached me so that I can teach you something. Now,
Absolutely.
now, when you finalize a law chamber for internship, your duty should be for initial 1 week or 2 week for that fact, just to see and just to analyze as to what is how the law chamber works. What is the problem हमारे साथ ये होती है that we know that we have to do internship, so we will join an office and we'll start working without even understanding what to work and how to work. Until and unless you see, in law there is a way, there's a set format, be it briefing, be it researching, be it drafting, whatever. Whenever you join a law chamber, request your senior for initial 1 week or 1.5 or 2 weeks for that fact, so that he should just grant you permission just to analyze as to how things go about in law chamber. Because you are entering this profession, internship meaning that you are learning. Learning requires you to know what is happening first. Until unless you don't know what is happening, how will you learn or how will you do? Hence, for initial 1.5 2 weeks, learn. Don't be hesitant, and that is the reason I believe I said this quite often. If you are not able to raise a voice for yourself, how can I imagine that you will raise a voice for your client? Why are you hesitant? Mostly students are hesitant because they are not able to converse in English language. And correct me if I'm wrong.
That's also a question we have further, sir.
Yes, yes.
There are.
My only point is it is okay. We are human beings. It is okay if we don't know English language. Please, and that is the problem. English has become more of a social status than a medium through
Yes.
which we can convey our thoughts. What is a language? Did you ever thought what is a language? What is the purpose of a language? Purpose of the language, any language for that fact you speak, is to convey whatever is in your mind, your thoughts. Now I am conveying my thoughts to you in English. You can convey your thoughts to me in Hindi.
Yes, sir.
Ultimately, what is important is conveying of thoughts. So whenever anybody says that I did receive, and I'm not defaming anybody, I did receive a lot of CVs which says language is spoken English. That's it. But you are an Indian. That means you're supposed to know your mother tongue, which is Hindi. But you don't write Hindi. Why? So please get out of this. If you are able to converse in Hindi, if you're comfortable in Hindi, speak in Hindi. But having said that, but that does not give you a leverage of not to speak in English. English is an acceptable language. It's the only acceptable language in Delhi High Court and Supreme Court of India. So if you're planning to do practice in Delhi High Court and Supreme Court of India, you will have to understand and speak English. Believe you me, and I'm not saying, I'm not lying. I also was not able. I also was not able to converse in English. अभी तो मैं बहुत जल्दी जल्दी बोल लेता हूँ and I've stayed in England and I have said all this. There was a time when I was not able to converse even one word in English. But I know that language is only for conversing, for giving my thoughts. Now I have to learn. There are thousands. Babbel is an app, and I'm sure it's available on all the. It's available on the iOS platform. I don't know whether it's available on the Android platform. Babbel is an app where you can learn, or you can go. Everything is available on YouTube. Everything. Go learn English if you're not good at it on YouTube or from that Babbel app. But don't let your weaknesses overpower your thoughts and ideas. Whatever you're not good, there is nothing on this planet which you cannot overcome. Believe you me. And I can say this from my personal experience. Personally, I was very poor, very. But I have reached today. I've reached with the grace of God, obviously. I've reached today a place where I don't think twice before spending, is because I have achieved the unachievable. 4 o'clock when you people are sleeping. I was in 2014 and 2015. I was entering Supreme Court at 4 o'clock in the morning because I did not have money to go to England, and I hate taking loans and I hate borrowing money from people. So please understand this, that without hard work you will not achieve anything. This, irrespective of the fact that you belong to a very fairly good class, very good family, you have to struggle. Struggle is part and parcel of this profession. The more you sweat, the better it is for you. The better people will listen to you. Today, I have reached the status where whenever I will speak or whenever I talk on any topic, people will listen. Why? Because I have achieved the unachievable. But anyways, coming back, I will not digress. Coming back, first, when you join a law chamber, make sure you ask your senior to give you 1.5 or 2 weeks just so that you can analyze as to how a law chamber works. And then when you've got a good grasp of what the situation is, how a briefing is done, how you see, understand this. Taking money from a client is also an art. Taking money from a client is also an art. You have to learn this. You have to understand how client is briefing his senior. You have to understand how one advocate is briefing the another advocate. How will you do that? How will you do that? Until unless you don't watch and learn. There are things which you have to watch and then learn. So watch first and then learn. And please, please don't be hesitant in saying whatever you have to say, irrespective of whatever language. If your senior, and I'm not afraid in saying this, if your senior has stopped talking to you just because you are not speaking in English, that means that person is not right to work with. And pardon me for my harsh words. ये आपकी मर्जी होनी चाहिए, आप किस भी लैंग्वेज में कॉन्वर्सेट कर सको. Please understand this. I hope I have answered the question.
And although you've mostly answered the question relating to how to approach an advocate and how to act in an internship, there's also a question that many law students have in relation to, it may be English, it may be in relation to confidence. That how do you suggest students that may be struggling to develop voting skills, especially in first year? How do you suggest them to improve their skills, and how do you suggest them to build their repertoire?
You see, the only way to develop your skill is to practice. So Moot courts in colleges are very, very important, and I urge everybody present, everybody listening to me, to please involve yourself into all college related extracurricular activities. The reason why I say this is because when you are mooting, or when you, and this especially for those students who are wanting to go abroad after their LLB, you are practicing for a moot court, you are debating. So in the process of preparation, you are learning how to do work in a team. That is developing your teamwork skills. Anyway, for that fact, the Britishers, when they are taking somebody, as in the fact that they are taking an international student, they are very, very focused on looking at these skills, and that is, you call it interpersonal skills. Develop these interpersonal skills, be it debate. So for example, if you are doing a moot court, you have to invite a judge. Now, there's a protocol, and I'm sorry I'm digressing, but there's a protocol of how you will address that judge while inviting, but you also have to be humble. Until and unless you don't invite, how will you learn? So, whatever requisites are there for a moot court, you can only learn, you can only learn by either watching first, but mostly you will learn only by doing it. So, get yourself involved in lot of extracurricular activities in your college, be it moot courts, be it debates, be it creating of a society and then inviting somebody, be it organizing a function, or whatever for that fact, but get yourself involved. Because until unless you don't do that, you will not improve on your skills. Because just by mere learning, seeing, you will not be able to develop it until unless you don't do it. Please do get yourself involved into all these extracurricular activities in college.
Yes, sir. Um,
Sir, there is a
I think
question
Abhishek
from
has a
comment
question.
section. There is a
Sorry,
question from comment section
please.
that when choosing a college for post graduation, what are the
Hmm.
main areas a student should focus on?
That now, okay, so that depends. I choose because you see, I when I was in third year of my college, because I was very frequently visiting courts, so I decided for myself that look, criminal law is that field where I want to litigate. So I started exploring more of criminal law. So by the time I sort of graduated my college, I was 100% sure that I wanted to pursue my litigation career in criminal law. Now, a question is asked that how do you choose what college to approach in what field? You see, especially and for those students who are willing to go abroad, and I can only talk about United Kingdom because that is where I've been. So I know in and out of UK now. Please understand this that UK requires your CV as well as your statement of purpose as to why have you chosen so and so college for pursuing this course. So now I applied to University of Oxford as well as Queen's University. First time, and I got rejected from both of them. Second time also I applied, but this time I got through. The reason being, you have to ask yourself. Okay, so before I say this, in UK, unlike US, unlike US, you there is something called as Russell Group, and because in UK, in US, there's something called as Ivy League, but in UK, there is called as Russell Group. So Russell Group is a group of 24 odd universities which are more research oriented. My suggestion to you would be apply to any of those 24 universities, but make sure that it has to be a Russell Group university. Now, in that Russell Group university, please see and explore the website of the college Because you see, this is a very big difference between the Britisher and an Indian. Whatever they say, they write it. So their process is very clear. Whatever they will say, whatever they will think, they will write, and whatever they will write, they will speak. यहाँ हम सोचते कुछ और है, बोलते कुछ और है और कहते कुछ और है, वहाँ ऐसा नहीं होता है. वहाँ पर whatever they will think, they will speak and they will write that. So now go on their website, see what college is good for what course. Like I chose Queen's because Queen's is supposed to be number third when it comes to criminal law, and number 8 in the entire UK for law. So I chose Queen's and I applied to Queen's, and finally I decided that look, these are the aspects, these are the professors who will be teaching me, and so and different factors that you can ask me later on also. The factors to be considered, which is the financial factors and all different factors are to be considered. But that's a long conversation. Uh, Whatever subject you want to do your masters or whatever you want to do in UK, go on to Google and type college best for criminal law in UK. That will give you a list. Go so example you've got a list of 3 colleges: Cambridge, Durham, Queen's. Go on the website of each college and see what topics will be, what is the syllabus, what all professors will be teaching, what are the qualifications of the professor, what is the rank of the college. So that way it will be very very good for you to finalizing your college when you're going, especially when you're going to UK. Because and I don't know about US, but UK requires a thorough research. And if I'm not wrong, and if my memory serves me right, I did a research of about 6 to 7 months, thorough everyday research, and then I finalized these 2 colleges. So if you're going to UK, please do a minimum research of 6 to 7 months. Only then you will be able to finalize the college you want to go. And then you have to look at various aspects like scholarship and accommodation and all these different things. Anyways, please.
Just one last question, sir, before we wrap up this session. Because I personally do have an interest in criminal law, so this is a question that I want to ask. That is,
Please.
what would your specific suggestions be for graduates thinking of entering litigation, especially in consideration with criminal law?
My first and foremost suggestion to you, if you are interested in criminal law, is target district courts for 3 years. Be it if you're living in Delhi, then Tisazari, Karkaruma, Rohini, Saket Court. You have to spend minimum 3 years understanding what the trial is, understanding various aspects of trial. First, FIR will be lodged, then investigation, then filing of the charge sheet, which is 173 clause 2. After filing of charge sheet, magistrate will take cognizance. After taking cognizance, he will issue process. After issue process, accused will appear, documents will be given. Then charge framing, then trial, then judgment, and then sentence. But this is supposed to be the sequence in which the entire criminal trial runs. But it is not as easy as I've said it. You have to analyze in depth. You see, the only way you can be, and I can tell you of my little experience of being a criminal lawyer. Obviously, the more you grow, the more you learn and everything, experiences also matter. Especially when you have to become a criminal lawyer, you have to develop this habit of finding loopholes. I, as a criminal defense lawyer, where I represent the accused, as a defense lawyer, I can only save my client who is accused of XYZ offense only when I'm able to find a loophole in the testimony of the prosecution witness. And the ability to find loopholes will only come when you understand and read threadbare each section. So break the section, understand each and every word, and after that, proceed and go see how that section is practically applicable in the court. So for example, if just taking one example, if a cognizable offense has taken place, The police, as per Lalita Kumar judgment, police is supposed to lodge an FIR. Now, if police is not lodging an FIR, what is the alternative remedy available to you? So you can approach the court under section 156 clause 3 of CRPC. Now, you can approach the court via 156 clause 3. So this is what is written in the book. But what is the practical aspect to it? The practical aspect to this is that along with section 156 clause 3 application, you will also file an application of section 200, which is complaint. And the magistrate, if does not deem fit that this case is appropriate for investigation of the police, will automatically convert that case into a complaint case and will start a complaint proceeding, that is from section 200 till 203. So this you will only be able to learn only when you go to trial courts. Don't start with High Court and Supreme Court will not teach you anything, that is for sure. Because Supreme Court only talks about law point. Unless you don't know the law, how can you talk about law point? So first spend 3 years in trial court, then because case comes from trial court to High Court and then from High Court to Supreme Court. This is a sequence. Don't break this sequence. Can spend considerable amount of time in trial court, about 3 years is minimum, and then subsequently go to the High Court and see how it happens in the appeal, and finally, God is kind and you will reach Supreme Court.
Thank you so much, sir. With this, I would like to take a moment to thank you for providing us with, again, the practical as well as the theoretical, and giving a great balance of both of those, and providing us with something that we can actually implement in our lives moving forward. And I also want to thank the audience for keeping this entire session interactive and for being patient and staying here. We really appreciate the questions that were raised by them, and we hope that we presented you with an interesting webinar.
I just want to say,
Yes, sir.
I'm so sorry to interrupt.
No.
And because Vanika said, thank you for being patient with me. With me, you have to be, because I was given a clear instructions from Vanika and the entire Lawocals team to keep it very precise and to the point. And I'm sure that they will call me after this and they will scold me because I have surpassed my time. And it is 7 o'clock. It was not supposed to be 7. And but anyways, but with me, and you see the reason why I do this. I mean, I don't do it intentionally, but the reason why I do this is because I have this habit of, because when I have to explain things, I don't, even if until unless I don't explain things in detail, you'll not be able to understand, and then you will not. Then the purpose of coming and spending your time about 2 hours or 3 hours will not be fruitful. So hence I have this, and the same habit goes when I conduct my workshops. So all the participants know कि अगर वो मेरे workshop में आ रहे हैं, so that means अगर 3 घंटे किया, तो it will be 4.5 hours. So pardon me for the extended time, please.
No issues. Thank you so much for ensuring that you gave us your all, and that we did not leave the audience wanting for more, or like thirsting for knowledge that they probably expected from the session. So I believe we've covered every topic that we could have in this specific period of time. Continuing with that, we at Lawocals shall be conducting more such webinars in the future to aid and ensure that all types of doubts and queries that come up with being in a law school are answered. And for that, I hope that everyone follows us on our social media platforms. All the updates will be given there in the future, and the links for same have been provided in the chat.